On February 23, 2024, Charlotte County deputies were sent to Charlie's Pub following reports of a woman suspected of driving while impaired with a young child inside her vehicle. Alarmed patrons at the bar informed officers the woman seemed severely intoxicated and unable to care for the child.
Your call has been updated.
Do you have another unit in that, please? Hello. Hope to go with the Sheriff's Office Traffic Safety Team. Reason I'm stopped at the Infinity is we had a call about your vehicle. They were concerned about your ability to operate a vehicle. Is everything okay? Right. Have you had anything, alcohol or anything to drink today? Are you on medications prescribed by a doctor?
Well, anxiety.
Okay. What?
Yeah.
How much have you had today?
My anxiety med?
We're right in the middle of the pharmacy.
It's fine.
Yes.
It's fine. Last night.
Okay. All right. What were you doing up at Charlie's Pub?
I stopped because I had to use the restroom.
Okay. Okay. Well, they're the ones that called. They were concerned about you being able to drive safely. All right. So I have another vehicle coming. How come you didn't, when I got out of the car to walk up to you, you didn't, you just took off on the access right there? Or did you not even see me?
No, I stopped as soon as I saw you.
No. No, I was behind you when you were at the stop sign. I was walking up to your car and you took off. Okay.
I'm sorry.
All right. Well, like I said, right now I'm just waiting. How old is the little baby?
She's 2 and he's 7 months.
Oh, okay.
Her.
Took her in the pub?
Yeah, I just had to use
You didn't take him?
No.
You left him in the car?
I left vehicle running. I just had to pee.
Okay. Tabor, 313's out with me. I'm going to do field sobriety, but she's got 2 babies in the car too, so I'll wait for a third to get here to watch them while I do her. At this time, ma'am, I am concerned about your ability to operate a vehicle safely. I'm seeing a couple of clues and indicators that believe that you may not be able to operate it safely. That I'm going to ask you to submit to field sobriety to make sure you're able to operate your Infinity safely today, okay? Will you do the exercises I'm going to ask of you?
I will.
All right. The first thing I'm going to do, Miss Patton, is I'm going to check your eyes. All right? So what I want you to do is stand with your feet together, arms at your side. You see that pen? I need you to focus on that pen. When I move it, I'm going to move it in a left to right fashion. You're going to follow it with your eyes and your eyes only, keeping your head completely straight. Do you understand?
Yes, I understand.
Do you have any questions?
No, I do not.
All right. All right, miss, this time we're going to go upwards. Same thing, just your eyes, head straight, okay?
Yes, sir.
Relax for a moment. All right, this time what I'm going to do is I'm going to go around your face in a circle twice. You're going to follow it with your eyes only. After I make that second turn, I'm going to bring it in close to your nose. I'm not going to touch your nose, it'll be very close.
Yes, sir.
As mine, what I'm trying to do is get your eyes to cross.
Yes, sir.
Okay?
Yes, sir.
All right, Miss Patton. This white line that you're standing on, do you see it?
Yes, sir.
Do you consider it a fairly straight line?
I do, sir.
Is it free of any debris that could cause you to trip?
No, sir.
It's not what's on it that could cause you to trip?
No, sir. No, sir.
No, I asked, is it free of any debris?
Oh, yes, sir.
Okay. I see that you're wearing sandals.
Sir.
Would you like to take those off and do it barefoot, or are you comfortable in your sandals?
I'm comfortable with my
right.
sandals, sir.
All right. What I'm going to do, ma'am, is this time I want you to put your left foot directly on the line. Take your right foot, place it directly in front of left like mine, arms at your side. Stay in that position. Do not start until I tell you to begin.
Sir.
When I tell you to begin, though, Miss Patton, you're going to take a series of steps, counting your steps out loud like such. Go ahead and assume the position. Right foot in front of left. All right. Nope, don't start yet. Wait till I tell you to start. So left foot on the line, right foot in front of left, touching heel to toe. Right foot in front of left.
Yes, sir, I am ready. I'm sorry. Yes, sir, I am ready.
All right, put your right foot in front of left. That's the starting position. Now begin.
Yes, sir.
Miss Patton, do you remember the instructions?
One in front of the other for nine
Yep.
steps?
And then turn and go back 9, right?
Okay.
How many steps did you take?
I didn't count. I'm
Okay.
sorry. Do you want me to start again?
No, just continue back the other way. Come back there. How many steps was that?
Honestly, I guess back.
Okay. All right.
I can do it again.
No, we're fine. Do you have a stopwatch for me in a second? Just wait right here on this line for me.
Yes, sir.
We got 2 more exercises to do.
Sir.
Oh, no, I'll just have you keep the time. It's fine.
Okay, yeah, let me get it ready.
All right. The next exercise is called the one-leg stand.
Sir.
Okay. When I tell you to, you're going to take the foot of your choice and you're going to raise it approximately 6 inches off the ground.
Sir.
It's going to look like this. The foot will be parallel to the ground, your arms will be straight, your legs will both be straight. 6 inches is like a Coke can. Think about resting your foot on top of a Coke can.
Sir.
You're going to count out loud in the manner of such. 1001, 1002, 1003. You're going to continue to count until I say stop. I'm not going to tell you how long I'm going to have you do it for, but I will tell you that I'm about to do it longer than I'm going to have you do it.
Sir.
If at any time you lose your balance or anything like that, and put your foot down. Regain your composure, pick that foot back up, and continue counting where you left off.
Sir.
So if you have to put it down on a 5, when you pick it back up, make sure we start counting again at 6.
Sir.
All right. Again, both legs are to remain straight. Foot is parallel to the ground, 6 inches off the ground. Arms are at your side. You're looking at your foot, and you're counting out loud 1001, 1002, 1003, and so on.
Sir.
Any questions on what I'm asking you to do?
No, sir.
Do you have what foot do you want to stand on, and what foot do you want to raise?
I'm going to stand on this, but can you block the wind? It's actually very strong.
It is windy.
Right now.
Like I said, I did just do it, but what I could do, I can stand to the side, but what I need you to do is.
I have no problem standing here. I just want you to
Yeah,
block it.
no. Do you have any physical handicaps or ailments that keeps you from doing this?
No, sir.
All right. So you're going to stand on your left and raise your right.
Sir.
All right. Begin. And you can stop. All right. Miss Patton, the last exercise is called the finger to nose.
Sir.
So what I need you to do is take both your fingers like this, index fingers. Now put them at your side, palms forward like mine. Remain in that position until I tell you to start. When I tell you, let's switch sides so the sun's not in your eyes. I'd rather have the sun in my eyes. When I tell you to start, you're going to have your head tilted back and your eyes shut. My eyes are staying open to watch you, but your eyes will be shut, okay?
Yes,
if
sir.
I say left, I'm going to call it a series of lefts or rights.
Sir.
If I say left, it's straight up, tip of the nose, tip of the finger, and right back down to your side.
Sir.
I will not remind you to put it down.
Sir.
If I say right, it'll be the exact same. Straight up, tip of nose, tip of finger, and right back down to your side.
Sir.
So we're clear, that's the tip of the finger. Not
Yes.
the nail, not the pad, not the sides.
Yes, sir.
If this is your nose, and that's the bridge, and those are your nostrils, it's literally the tip to tip. So it's like this. Nope, like this. Straight on, and
So,
then right down.
this.
This. Just
This.
like that. Yes,
So,
ma'am.
turn it around to
Yep,
my...
to your nose and right back
Sir.
down to your side.
Sir.
All right, Miss Patton, head back, eyes shut, left, right. Remember the instructions. Remember the instructions.
This.
You gotta put your hand down.
Oh, sorry. Sorry, sir.
Left, right, got one last exercise. It's a balance exercise.
Sure.
Face that stop sign real quick. I'm going to explain how to balance for you real quick in a minute. Left him at the jail. Miss Amanda, at this time you're under arrest for DUI. Do you have somebody that can come get the children? Who can come get the children? All right, we need to call him. I don't want to have BCF have to come out here for him. What's your husband's phone number?
Tell me why I'm being cuffed.
You're being arrested for DUI. Driving under the influence. And that influence encompasses alcohol and medications. You're being arrested because you're not able to drive that vehicle safely. The clues and indicators you provided me during field sobriety are enough to affect the arrest on you. So what's your husband's name?
Charles.
Charles.
You want to tell me what I failed?
It's not pass or fail, but I'll tell you that you gave me enough clues and indicators to arrest you.
Oh, did I?
Oh, yes. Absolutely.
My anxiety medicine that I didn't tell you about have anything to do with this?
Absolutely.
My steroids?
Absolutely.
All right.
If you look at your medication bottle, it says do not operate machinery.
No, and
It absolutely.
that I didn't tell you about.
Okay. It could be. I'm not sure what that is, but you gotta take a seat, Amanda.
Picture yourself pulling into a familiar parking lot near the end of an ordinary day. The engine is still warm. The lights of nearby storefronts reflect off the windshield. Nothing feels dangerous. Nothing feels criminal. This is the kind of place where people pause for a moment, run a quick errand, and leave without consequence. Now picture this moment ending in handcuffs. Not after a chase. Not after a crash. Not after anyone is hurt. But here, before anything visibly goes wrong. Before voices rise. Before anyone believes they are in trouble. This is where a common legal myth quietly collapses. Most people believe that arrest only follows chaos, that custody only happens after recklessness becomes obvious. That jail exposure requires something dramatic, an accident, a refusal, a clear line crossed in public view. And for the first few seconds of this encounter, that belief feels completely reasonable. Nothing illegal appears to be happening yet. But the camera keeps rolling. Time does not pause. And the law does not wait for outcomes, only thresholds. Decisions that feel temporary begin to stack. Choices that feel harmless start to narrow the exit. By the end of this encounter, one adult will lose physical freedom. 2 children will be placed in temporary custody arrangements, and the setting that felt routine moments earlier will become the entry point into the criminal justice system. What matters most is not what happens next, but what has already happened before anyone realizes control is gone. The central legal question in this case is deceptively simple. When does a lawful everyday decision become grounds for arrest without any accident, injury, or visible chaos? Most people carry a powerful legal myth into encounters like this. The belief is that as long as no one is hurt, no law has truly been broken. That intent matters more than outcome. That explanations can slow or stop the process before it escalates. That belief is wrong. By the end of this video, you will understand why the thing she believed would protect her is exactly what made arrest inevitable. This case is not about punishment for a mistake. It is about thresholds. The moment when behavior crosses from personal discretion into legally actionable risk, whether the person involved recognizes it or not. Everything that follows hinges on that misunderstanding. What follows unfolds over a short window of time, in a location designed to feel routine. A vehicle draws attention not because of speed or impact, but because someone nearby becomes concerned enough to make a call. That single decision introduces authority into a space where none was expected. The interaction begins calmly. Questions are asked. Answers are given. On the surface, everything appears cooperative. There is no argument. No visible emergency. No immediate restriction of movement. At this stage, the situation remains legally fluid. But the timeline tightens quickly. Information begins to accumulate small details that do not individually trigger action, but together start to form a picture. Presence in a particular place. A brief stop that was not as brief as described. The presence of children who cannot independently protect themselves. Each fact narrows the range of legally acceptable outcomes. This is not a single event escalation. It is a convergence. The authority involved does not need proof of harm. The law does not require a completed disaster. What it requires is sufficient basis to believe that continuing the status quo creates an unacceptable risk. By the time the next procedural step is initiated, the encounter has already crossed an invisible line. The setting has not changed. The tone has not dramatically shifted. but the legal posture has. From this point forward, the process is no longer optional. The pivot in this case does not come from confrontation or defiance. It comes from disclosure. Everything changes here. Up to this point, the encounter exists in a zone of assessment. Questions are being asked to determine risk, not to assign guilt. The legal dynamic is still flexible because uncertainty remains. Authority is evaluating whether intervention is necessary or whether the situation can safely resolve without further action. That balance shifts the moment critical information enters the record. The presence of young children transforms the analysis. Not emotionally, legally. The standard is no longer limited to whether an adult can continue freely. It expands to whether others, who lack agency and choice, are being placed in potential danger. At that moment, the scope of responsibility widens. The moment that fact becomes clear, the legal dynamic shifts. This is no longer about inconvenience or poor judgment. It becomes a question of risk management under the law. The threshold changes from subjective belief to objectively reasonable concern. Once that threshold is met, discretion narrows sharply. From here forward, the encounter is governed less by conversation and more by procedure. The options that existed minutes earlier quietly disappear. What remains is a structured process designed to prevent harm before it occurs. And once that process begins, it does not reverse itself. The core legal axis in this case is not punishment for past harm. It is probable cause based on risk, evaluated under an objectively reasonable standard. Here is the myth that collapses first. If no accident happened, there is no legal basis for arrest. That is incorrect. The statute governing DUI and related endangerment does not require damage, injury, or intent. It requires a threshold determination, whether a reasonable officer, given the totality of observable facts, would believe the individual is not able to operate a vehicle safely. This is where explanation becomes irrelevant. Statements about intent, stress, or necessity do not negate the standard. The law draws a clear line between speech and conduct. What someone says they meant to do does not override what their actions objectively demonstrate. Likewise, annoyance does not equal threat, but risk does not require hostility. This is where assessment becomes action. Field evaluations are not designed to produce perfection or failure in isolation. They exist to observe coordination, attention, and compliance under structured conditions. Errors do not need to be dramatic. They only need to be consistent enough to establish impairment under the statute. This is where discretion narrows. Once sufficient indicators are present, probable cause solidifies. At that point, continuing to allow operation of the vehicle becomes legally indefensible. The officer's duty shifts from observation to prevention. This is where freedom becomes custody. The presence of minors elevates the stakes further. What might otherwise result in a citation now carries the potential for enhanced charges, not because of moral outrage, but because the law imposes a higher duty of care when others cannot protect themselves. At this stage, arrest is no longer optional. It is the legally required outcome of the threshold being met. Two counter-narratives typically surface in cases like this, and neither alters the legal outcome. The first is mental health as a shield. Anxiety, stress, or prescribed medication are often raised as explanations after the fact. Under the law, explanations are not disqualifiers. The test is not why impairment exists, but whether it exists. The standard remains objective. Would a reasonable officer believe the individual could not safely operate a vehicle at that moment? Mental health context does not replace that analysis. It does not suspend the threshold. Conduct controls the outcome. The second is overreaction by authority. This argument assumes discretion remains unlimited. It does not. Once probable cause is established, discretion contracts. The officer is no longer weighing preferences. They are executing a duty. Allowing a potentially impaired driver to leave, especially when minors are involved, would itself violate policy and statute. This is where perception diverges from law. Force is not required for custody, aggression is not required for arrest, and empathy does not override obligation. The system evaluates behavior against standards, not narratives against feelings. At this stage, the process is no longer negotiable. It is procedural. What emerges from this encounter is not a diagnosis. It is a recognizable behavioral pattern. This is not a mental health diagnosis. This is a behavioral pattern. The pattern is rooted in authority, confusion, the belief that personal explanations can delay or reshape formal processes. It is reinforced by entitlement insulation, where routine privileges of daily life create the impression that ordinary rules flex in private moments. When pressure increases, responsibility is reframed as misunderstanding rather than risk. This pattern often includes selective compliance. Cooperation is offered until outcomes become inconvenient. At that point, accountability is experienced as unfair escalation instead of predictable consequence. The individual does not see themselves as opposing authority, but as exempt from its final step. The law does not operate on that distinction. From a legal perspective, behavior either meets a threshold or it does not. Once it does, status, intent, and explanation lose controlling weight. The system moves forward regardless of internal belief. This pattern is common precisely because it feels reasonable until the moment it fails. Once the threshold is crossed, the outcome follows a defined legal path. The charge is specific and procedural. An arrest is made based on probable cause. Custody is established. Booking begins. From that point forward, discretion shifts from the roadside to the system. The immediate consequence is loss of physical freedom. Transport, processing, temporary confinement. These are not symbolic actions. They are mechanisms designed to remove risk from public space. When minors are involved, parallel procedures activate to ensure their safety until a lawful guardian can assume responsibility. Financial exposure follows. Bail conditions, fines, court costs, mandatory evaluations, potential license restrictions. Each consequence flows from statute, not sentiment. The law does not recalibrate itself based on intention after the fact. This is where the broader structure becomes visible. The legal system is not reacting to outrage. It is restoring order. It intervenes before harm occurs, because prevention is embedded in its design. Freedom exists within limits precisely because those limits protect others who cannot consent to risk. This outcome is not negotiable once the process begins. It is not reversible by explanation, and it is not personal. The same standards apply in quiet parking lots as they do on busy highways. Order is not oppression. It is the framework that allows freedom to function without collapsing into danger. And once the law steps in to restore that order, it does not step back.